Hi folks, this is an introduction to Module 8, which is about legal theory. And legal theory is one of those topics which traditionally divides students. There's some students who love it and love the sort of aspect of philosophy and thought that's in it. And there are other students who see it as sort of very remote and sort of theoretical and not of direct application to them. Now, I'd prefer to see a middle way, in that what theory provides you with is a set of tools that help you solve practical problems. So theory for its own sake, yeah, some people like that. They like the abstract kind of what-if issue, and look, if you like that, that's fine. But for me, the real advantage of theory is it gives you a set of different lenses that you can put on a situation where you don't have an easy answer to start thinking about your problem in a different way. So let's look at the example, and I'll return to this, the idea of gendered violence, and particularly domestic violence and intimate homicide. It's a big issue for law, it's a big issue for criminology. Criminologists, of course, are more concerned with why it happens and to prevent it, and lawyers are more focused on the legal response and how the legal system works, and does the legal system actually, improve the situation. And it's such a, particularly with recent examples of family murder, suicides and issues like that, it is such a horrible, intractable kind of a problem that our intuitive and common sense responses and don't necessarily get us very far. I mean, just a common sense look at that issue, it's like, are the men who do it evil? In which case, we're not regulatable, and there certainly is a way in which what they do is like what some of the, particularly where children are murdered, it's some of the most profound kind of evil that we could imagine. Is it a situation where the law isn't harsh enough? Well, when it's a murder-suicide, there's not really much in terms of the law can do to deter this situation. So our ordinary common sense responses to that problem leave us in a bit of a dead end. But what theory does is it tries to bring us ways of thinking about the phenomenon itself or about the legal response to it, and understanding that and looking at it from different points of view and saying, well, does that help us understand it? Does it give us a fresh perspective? And does it enable, and it enables us to do a few things. What theory generally does is it allows us, first of all, to try and explain what goes on. Because we can say, according to this theory, this is one way we can explain something that we otherwise find to be inexplicable or difficult to explain. It also provides links and connections to other phenomena that may help understand a big picture, and theory can work as a key to pattern recognition. So if we find, for instance, if we're looking at issues like toxic masculinity, we might find there's all sorts of connections to things like the issue of consent in sexual assault, issues around the incel movement. There might be all sorts of different areas where we can start making those connections of the way in which toxic masculinity goes wrong and influences this sort of behaviour. So that's the second thing that theory can do for you, is it can actually make a network of ideas that are all connected together. And the third thing that theory can do, always a bit vexed, is to try and predict outcomes and to try and say, well, according to the theory, this is the sort of thing that will happen in the future. And notoriously, theories are hard to prove, and theories always go wrong. But it's that process, and this is part of the scientific method of putting forward a hypothesis, testing it, and then reflecting back on your hypothesis is a way to advance knowledge. And then your hypothesis isn't proven, but then you adjust it and go back and test it again. So theory, for me, I think it's very useful to think about it in this practical way, and less about sort of thought experiments and abstract and things, but more in terms of how does this actually help us as a problem-solving technique. Now, the chapter in the textbook, I admit, is a bit of a mixed bag. It doesn't have a very clear kind of through line, and it throws a lot of sort of bits and pieces together, but I'll just talk through it. Obviously, I'm not going to explain everything that's in it, because otherwise, there's no value in you reading, but I'll give it a bit of context, because I think it's one of the weeks where it doesn't have a weak, it doesn't have a strong central story that goes through this chapter. It just seems to be a few different things they felt that needed to go in. And even the chapter title, being realistic, is like well, we talk about legal realism as a thing, but it's not a chapter about being realistic. It's about using theory. So who knows why it was. But yeah, if you went into the chapter reading it and went thought, oh, being realistic, this is going to be about, you know, realistic day-to-day issues, and then suddenly it's like, oh, these theorists say this and this about law, it may be a little confusing. All right, so the difference between legal formalism and legal realism is a big part of the first part of the chapter, and really this is about the degree to which our understanding of law can be seen as a phenomenon separate to the rest of society. So law has its origins in an idea that law is very self-contained and is not and objective, and it's something that is not influenced by society, and there's lots of historical reasons for this. And it was until the 20th century this idea that judges sat, you know, like the gods of Mount Olympus above everyone else, and made decisions purely on what the law had to say, and that law was not affected by the politics and social surrounding. There's a whole history in that, and it's something that if you're interested in legal theory, you could spend more time unpacking, but let's not today. But it meant that there was this sort of institutional blindness to the politics that actually did influence what judges said, because judges, like everyone, are informed by their location in society, their background, you know, their relationships with others. It's not bad that law sought to be objective. That's a good thing, and the idea that lawyers seek to rise above individual concerns and try to put those aside and make judgments on the basis of the law, that's good. But it does end up with that weird situation, like the Jedi Knights of old, where if you put yourself into absolute denial about your own self-interest, then you're blind to the fact by denying it. So it's, you know, today we've got a more realistic approach, which came through the school of legal realism, where we say, of course, judges are socially located, but by acknowledging that, we can try and overcome that and be more objective, because you can look at something and go, okay, this is my judgment, this is what the law tells me, but am I being influenced by my own preconceptions? And if I think I am, can I ask more questions, and can I find out more about that location? So we've had a whole history of law relating to provocation and self-defense that were based on, they've changed now, but they're based on basically dueling rules. And, you know, if someone provoked you, you had to fight them fairly, and self-defense, you had to be commensurate, and, you know, you had to have swords of the same length and pistols at the same, whatever. There had to be this sense of gentleman chivalry around criminal law that allowed some leeway for dueling, but basically tried to discourage it, but didn't allow you to, use unfair force or disproportionate force. Now, those laws were notoriously bad when it came to women who kill abusive partners, particularly where there's a history of torture and a history of abuse in the background. And there was a whole series of law reforms that had to occur before we acknowledged that a woman who is in that position, who kills an abusive partner, is not going to say, okay, let's stand up face to face and let's fight this out fairly, fisticuffs at dawn or swords at dawn, that those rules just don't apply. So there's an example of a situation where the legal rules were defined by chivalry, and for years the law just said, well, those are the objective rules because that's the way things were done, until people started to critique them and take them apart and say, no, these are socially situated rules that come out of a history, and they need to be changed because they don't reflect the experience of people who have been, methodically, physically abused and tortured, who aren't going to turn around and say, let's make it a fair fight, because they've got no other options. So that we went through that in the 80s and 90s, we've changed the laws. That's an issue for another day to explore how that happened and what happened. But the point I guess I'm making is that it's an example of the way that legal realism as a way of thinking allowed us to take apart what seemed to be objective, what seemed to be natural, what seemed to be, just the only way the law should operate. All right. So the rest of the chapter, the first part of the chapter, looks at a few key theorists, largely from the American tradition, who are somewhere in between those two different ideas of law being formal, where the rules of law are in their own little world, they're completely objective, and judges' role is purely to mechanically and methodically apply those rules and to come up with an outcome. And the other sort of far extreme, which is acknowledging that judges are socially situated and they're going to bring their own values to the way in which they judge. And most of us are somewhere in between. We would like judges to be objective, but we also recognise legal realism, that they're people, and that's going to affect the kinds of judgments that are made. So any particular judgment is going to have some balance of these are what the rules are and these are how we apply them in the social situation that we're in. So just to briefly mention the theorists that they look at, and don't worry if the scope of what the theorists say seems a bit forbidding at the moment. Just start being acquainted with the broad ideas that they're putting forth, and to think about going forward, what does that mean for your own understanding of legal and regulatory systems. So HEA Heart is the first one that's mentioned, and he talks a lot about the penumbra of uncertainty within laws, that basically, there's the really clear cases that something is included within a legal rule. There's the really clear cases where something's not included in a legal rule, and where the job of law is about the in-between. The situation where, it's not completely certain, it's not completely certain it's in or out, and judgment is about those edge cases. And I've talked about this in the primer when I talk about finding the zone of uncertainty. That the key, most everyday legal regulatory questions are one thing or the other. It's like, you are either driving at 68 kilometres an hour in a 60 zone, or you're driving at 55 kilometres an hour in a 60 zone, and the rules reasonably clear. But where you get the edge cases are where law becomes interesting, and where the role of judgment becomes much more important, and someone actually has to exercise a discretion and make a ruling on something. So where things don't have a metric assigned to them, so compared to, say, driving over a speed limit, driving dangerously, and someone has to make a judgment of, well, what is dangerously and how do we prove that? And that's an example of somewhere where there's a much bigger penumbra of indecision. We also, so law, needs a bit of wiggle room. It needs a bit of area for discretion, and the question is, how large should that be, and what is the role of judgment in making those decisions? Compare to Fuller, and Lon Fuller is much more focused on the purpose of law, and he's much more down the realist end of the scale, and he's saying that we need to avoid situations where interpretation of the legal rules lead to that sort of legal fidgy-widginess where you get bizarre and weird application, and it should always be really returning to the the framers of the law, be it the founding fathers of a constitution or the parliament who passed an act. What were their intentions? And that's the most important thing when we come to interpreting the law. As critics have pointed out, though, one of the problems with that is, first of all, it's really hard to figure out what the intentions are. If you've got a parliament of, 60 people who vote on a bill and 48 vote in favour of it, how do we know what their reasons or intentions were? They can all be quite different. And the example of even the founding fathers, people often refer to the United States situation, the right to bear arms, and how that's, at the time no one knew, there was no idea that there would be assault rifles and laser scopes and all those sorts of things. So how can we figure out what the framers of the Bill of Rights in the US meant when there's things that they wouldn't have known about at the time, and there's huge amounts of stuff written about this. So if you're interested in this, we can point you into some of the directions, and this is somewhere you could spend a whole career investigating. But for most of us, this is just a case of flagging that these are the interesting topics that people have brought up, and they give you a different way of thinking about that process of judgment, and how, sometimes it's easy. You look at the rules, you look at the speed limit, and you go, yep, that's over, yep, that's under. But a lot of the times, and particularly the things that actually make their way to court, it's the situations where you go, well, don't know. This is not something that falls directly in the meaning of the rule. So we have to look at the precedents and try and see if the precedents help us understand it. And when we make a ruling, it's going to create a precedent, and it's going to be important going forward. All right, who else did we look at? Ronald Dworkin, not to be mistaken for Andrea Dworkin, completely different theorist. Ronald Dworkin looks at the idea of legal principles, and he said that even sometimes where you see a decision that seems arbitrary, where a judge looks in this sort of penumbral, and penumbra, by the way, means shadow. It's just a fancy legal term to exclude everyone else, and that's why I talk about zone of uncertainty, because at least we all know what that means. But Dworkin says that even if sometimes you look at something and a judge says, I'm making a ruling here, and it doesn't necessarily seem to be based on, or the judge doesn't express it to be based on a particular line of reasoning, they're underlying legal principles. And what's really interesting is to understand things like rule of law, principle of fairness, idea of rights, all that stuff we've been hitting you with throughout this term, how all those ideas underpin that sort of judgment. So he says that, there's a whole, I basically think, he doesn't say it like this, but there's a culture. There's like a whole series of culture that goes into understanding the way that those people think. And the part of becoming literate in the world of law, whether you're a lawyer or someone who works in the criminal justice system, is understanding how those principles lead to judgments. And the idea of an education will be to raise those principles and to think about, okay, how does that make sense of these decisions? So that's just a very quick introduction to some of the main thinkers in that sphere of thought. And I think this is stuff that's just interesting to keep in the back of your mind going forward. I'm a systems thinker, which is not something that has a big following in law as yet, but I tend to think about these as complex and adaptive systems. That the law is always walking this tightrope between being way too certain and too rigid, and too uncertain and too flexible. In which case we can't predict what it's going to do. And this is an interesting way that systems adapt over time to move back and forth between, really rigid, well-defined rules, then realising that we need more wiggle room, and they expand. And then we see that, there's too much wiggle room, no one knows what's going to happen next, and we've got to restrict them again. So there's interesting things to be said in the broad picture about the way that legal and justice system evolves as a system. Alright, so the rest of the chapter goes in a couple of different directions. The next section talks a little bit about legal realists. And that was a school of thought which basically responded to a lot of this deep and meaningful stuff about what law is by saying, rather than looking at what law is in an abstract term, maybe we should look at what law does. And actually they started really focusing on the job law does in society in terms of managing conflicts, achieving outcomes, and rather than trying to find an abstract framework for the development of the law, actually saying, well, does it really matter? We can debate all day whether it's this or that or whatever. Let's actually look at, what is law's success rate in terms of actually resolving disputes? What are the situations where law actually exacerbates disputes and makes things worse? Let's actually look at that sort of focus. So when we talk about legal realism, there's also that sense of saying we have a different research agenda and a much more practical and a much more social science informed research agenda that's less about, the ivory tower philosopher thinking about things, and more about let's try and see what are the cleanup rates, what are the success rates, what's the empirical data we're getting from the system and whether it's working or not. All right, so the rest of the chapter then goes in another direction, and it talks a bit about judicial activism and some of the questions that have happened about, and that's already been, I guess, underlined in the material we've discussed so far. You know, to what extent should a judge be being activist and actively seeking to change the law where there are problems, and to what extent should the judge just say, oh, that's the law, that's the way it is, that's the way it always will be. And that's in many ways an insoluble decision. And it's also a highly politicised decision, because quite often when judges are behaving in a very rational way under legal rules, people who don't like the outcomes are going to the media and saying it's just judicial activism. The Mabo decision is a classic example of this. I mean, the Mabo decision, the removal of terra nullius, was a complete lie. Like, legalistically, it was a real, it was just concocted, right? And what the Mabo decision really did, if you're looking at it as a legal formalism, was to get rid of a legal lie that was told to avoid the operation of the normal area of law, which was when you have people's legal systems in conflict, you know, you have to have a treaty, and if you don't have a treaty, this is the way the systems interact. And then we invented this thing called terra nullius to explain why we weren't following the rules. So the Mabo decision, just to totally oversimplify it, was the High Court saying, we're not going to keep following this thing because it's a lie. We're going to go back to the conventional legal rules that everyone else follows. But, of course, that led to a whole, storm in the media, led by the Attorney General at the time, saying that, it's just judicial activism, the judges have no role in making these decisions, whatever. And, you end up with people co-opting the political process and the media process because they don't like the natural application of the law. And that was actually the first time the High Court of Australia spoke to the media, because they have a policy of not speaking to the media about their judgments, because they say you're going to just end up second-guessing yourself if you have to keep responding to something you've already laid down in a judgment. And part of judicial independence is that you don't you say the judgment once, you're not going to keep going back and talking about it. But there was so much furor from Parliament at the time, and it was led by the Attorney General, and one of the jobs of the Attorney General is always to defend the court, and at that time the Attorney General was the one attacking the court. So interesting times. But at the time, that was the time when they actually spoke to a documentary maker, and the members of the High Court talked about what they did, because they felt that they could not necessarily, they weren't going to talk directly about Mabo, but they wanted to sort of speak to the people of Australia about what it was they did and how they did it, because they felt that they were being undermined for political purpose, and that was happening. So the question of judicial activism is often about, who doesn't like what judges have said, and how are they using their position of influence to try and slag off the court for political gains. There's not really, it's not like judges are out there spraying anarchy signs on the walls and being, overtly activist, but they are cleaning up the law where they see there are problems, and that's how that debate usually falls out. All right, the rest of the chapter looks at some of the different critical theories around law. So it looks at Marxist theory, critical legal studies, postmodernism, feminist legal theory, critical race theory, and a lot of the different perspectives, which, as I mentioned at the outset, create a different lens with which to look at the law. Now, these are all very, very important, very, very valid positions, but I think, given that there's been so much focus on the legal realists and legal formalists in this section, that it sort of does a bit of a disservice to tack this on as just an afterthought. So I think that you should read through these sections and be familiar with the critiques, but this is something that you'll return to if you're law students in jurisprudence. If you're criminology students, will come back in your criminologic theories. So these are themes that you're going to return to, but just be aware that they're there. Just be aware that there's been generations of feminist legal scholars who've looked at things like, the self-defense provocation rules I mentioned at the outset, and looked at the way in which those are gendered and constructed in a gendered way. And the work of those theorists have led to changing in the law. And the same for the different perspectives that they've taken, where the law says, well, what we do is just the way everyone thinks, and have said, well, no, lawyers and judges, you historically have been from a very narrow group of people in society, and you don't know what you don't know, and you don't know sometimes that you're blind to difference in the system and the way that the law does not operate equally, even when it is expressed in an equal way. Anatoly France said, the law, it is equal in that it prohibits everyone, both rich and poor, from begging and from sleeping under bridges. And that's been, as a classic statement of where something seems formal, seems formally equal and fair. No one's allowed to sleep under bridges. No one's allowed to go begging in the streets. But of course, it operates very differently if you're a rich person or a poor person. And the history of these different critical perspectives on law have been exposing the different ways in which the law often says, oh, well, everyone does this, and actually isn't necessarily from a universal perspective. It's often from that perspective of privilege. So I don't want to diminish those theories by glossing over them, and I think it's important you have a look at them. Beg your pardon. But I also think that we've got enough to go on with this first part of the problem, which is the focus of the tutorial questions this week. And we really, those critical issues are ones we're going to look at in different formats elsewhere in the courses that you're studying. So let's have a look at those first ones in more depth. Okay, I will have a chat with some of you later in the daytime workshops.